The screen of your phone lights up with a notification from USCIS, and your heart starts racing. You click on it, hoping for good news about your family immigration case. If you've been waiting months or even years to bring your loved ones to the United States, what I'm about to share with you could completely change your timeline. USCIS just dropped some massive updates this November 2025 that directly affect Form I-130 processing and whether you're a U.S. citizen trying to sponsor your spouse, parents, or children, or a green card holder hoping to reunite with family members. You absolutely need to know about these changes because they could mean the difference between waiting another year or finally seeing your family walk through that airport terminal. Welcome back to the channel. And if you're new here, we break down the most important immigration updates in plain English so you can actually understand what's happening with your case. Today, we're diving deep into the November 2025 USCIS announcements regarding I-130 petitions for family-based immigration. And trust me, this is not the typical bureaucratic update you can ignore. These changes are affecting processing times, priority categories, and even how certain applications are being reviewed. Make sure you stick around until the end, because I'll tell you exactly what you need to do right now based on your specific situation, and I'll share some insider tips that could help speed up your case. And hey, if this information helps you, do me a favor and hit that subscribe button so we can keep bringing you these critical updates. Let's start with the biggest news that has everyone talking. USCIS announced significant adjustments to their processing timelines for I-130 petitions, and the changes vary dramatically depending on which service center is handling your case and what relationship category you fall under. For immediate relatives of U.S. citizens, which includes spouses, unmarried children under 21, and parents of U.S. citizens who are at least 21 years old, the average processing time has actually improved at some service centers. The Nebraska Service Center is now processing these cases in approximately 9 to 12 months, which is down from the 15 to 18-month range we saw earlier this year. The Texas Service Center has also shown improvement, bringing their average down to 10 to 13 months. However, and this is important, the Potomac Service Center is still experiencing delays, with processing times hovering around 14 to 17 months. Now, if you're a lawful permanent resident sponsoring family members, the picture looks a bit different. These fall under preference categories rather than immediate relative categories, and the processing times reflect that distinction. The F2A category, which covers spouses and unmarried children under 21 of green card holders, is seeing processing times between 12 and 16 months at most service centers. What's particularly interesting is that USCIS has indicated they're allocating additional resources to this category because they recognize the humanitarian importance of keeping nuclear families together. Here's where things get really interesting and where you need to pay close attention. USCIS announced in their November update that they're implementing a new pilot program for certain I-130 cases. This program involves enhanced processing for petitions that meet specific criteria, including complete documentation, clear evidence of relationship, and cases where the beneficiary is already in the United States on a valid visa. If your case qualifies for this pilot program, you could see approval in as little as 6 to 8 months. The catch is that not everyone automatically gets enrolled in this program. USCIS is using a combination of factors to determine eligibility, and they've stated that cases involving petitioners with a history of approved petitions, complete financial documentation, and no prior immigration violations are more likely to be selected for expedited review. Another major piece of news from this November update involves the documentary requirements for proving bona fide marriages. USCIS has updated their policy manual to provide clear guidance on what constitutes sufficient evidence of a genuine marital relationship. They're now explicitly stating that they want to see evidence spanning the entire period of the relationship, not just documentation from around the wedding date. This means if you got married 6 months ago, they want to see evidence of your relationship for those entire 6 months. They're looking for a combination of financial commingling, shared living arrangements, joint obligations, and social recognition of the relationship by family and friends. What's new is that they're now giving more weight to digital evidence, including text message threads, social media interactions, and even shared streaming service accounts, recognizing that modern relationships leave different footprints than they did 20 years ago. For those of you who have been stuck in the administrative processing nightmare, there's some potentially good news. USCIS announced that they're working more closely with consular posts to reduce the backlog of cases that have been pending additional review. They've created new interagency task forces specifically designed to clear cases that have been sitting in limbo for over 6 months. If your I-130 was approved, but your family member has been stuck in administrative processing at a U.S. embassy or consulate abroad, this initiative could finally break through that logjam. Let's talk about request for evidence notices because this is where a lot of people stumble. The November update included new guidance about how USCIS is handling RFEs for I-130 petitions. They're now required to provide more specific explanations about what evidence is missing or insufficient, and they're giving petitioners more reasonable timeframes to respond. The standard response time remains 87 days, but they're now allowing for extensions in cases involving overseas evidence collection or certified translations. What this means for you is that if you get an RFA, you need to read it very carefully and respond with exactly what they're asking for. Don't send them 100 pages of random documents. Be surgical in your response and address each point they raised. There's also important news about fee changes that affect I-130 filers. While the filing fee for the I-130 itself remains at $535, USCIS has announced that starting in early 2026, they'll be implementing a new fee structure that could affect certain supplementary forms and services. They're also expanding their fee waiver program, which means that some petitioners who are experiencing financial hardship may qualify to have their filing fees reduced or eliminated. The eligibility criteria for fee waivers has been broadened to include more middle-income families who might be struggling with the cost of immigration applications. One of the most significant announcements that hasn't gotten enough attention is the expansion of online filing for I-130 petitions. USCIS is pushing hard to move more of the immigration system online, and they're incentivizing electronic filing by promising faster processing times and easier case tracking for petitions filed through their online portal. If you file online, you get real-time updates. You can upload supporting documents directly without worrying about mail delivery, and you can even communicate with USCIS through the portal if they need clarification on something. The paper filing process isn't going away, but it's clear that USCIS wants to move everyone to digital submissions. For those of you sponsoring parents, there's specific news that affects you. USCIS has noted that I-130 petitions for parents of U.S. citizens are generally being processed faster than other categories because they're straightforward and don't require priority date tracking since they're immediate relatives. However, they've also tightened up their scrutiny of these cases, particularly looking for evidence that the parent-child relationship is legitimate. They want to see birth certificates, but they're also asking for additional evidence in cases where the birth certificate might be questionable or where there are inconsistencies in the family history. Now let's address something that affects people who made mistakes on their initial filing. USCIS has clarified their policy on accepting corrections and amendments to I-130 petitions. If you realize after filing that you made an error, you can submit a corrected form along with an explanation letter. However, the key is timing. If USCIS has already identified the error and issued an RFE or denial notice, your ability to correct it becomes more limited. This is why it's crucial to triple-check everything before you submit. And if you do discover an error, notify USCIS immediately rather than hoping they won't notice. Here's something that directly affects those of you who are in the United States on temporary visas while your I-130 is pending. USCIS has reaffirmed that filing an I-130 does not automatically jeopardize your current visa status, but they've also made it clear that if you're on a non-immigrant visa that requires you to maintain non-immigrant intent, having a pending I-130 could complicate future visa renewals or extensions. This is a nuanced area where you really need to understand the specific rules for your visa category. The November update also touched on how USCIS is handling cases involving beneficiaries from countries with significant backlogs. While the I-130 processing itself might move relatively quickly, the wait for a visa number in certain preference categories can stretch into decades for applicants from countries like Mexico, Philippines, India, and China. USCIS has announced they're working with the State Department to provide better transparency about visa bulletin predictions and priority date movement. But they've been honest that there's no magic solution to the visa number shortage in these categories. So what should you do right now based on all this information? If you haven't filed your I-130 yet, seriously, consider filing online to take advantage of faster processing and better tracking. Make absolutely sure your evidence package is complete and comprehensive because the new guidelines show that USCIS wants to see the full picture of your relationship. If you have a pending I-130 and haven't heard anything in a while, use the online case status tool to check for updates. And if you're outside normal processing times, you can submit an inquiry through the USCIS Contact Center. If you received an RFE, respond quickly and thoroughly because the new guidance shows they're being more specific about what they need, which means they're also less forgiving of incomplete responses. This has been your comprehensive breakdown of the major I-130 updates from USCIS this November 2025. The immigration system is constantly evolving, and staying informed about these changes can make a real difference in your case outcome and timeline. Remember, every situation is unique, and while this information gives you a solid overview of what's happening, it's not a substitute for personalized legal advice, especially if your case has complicated factors. If you found this video helpful, smash that like button, drop a comment below telling me what your biggest concern is about your family immigration case, and make sure you're subscribed with notifications turned on because I'll be monitoring these updates throughout the rest of November and December. Share this video with anyone you know who's going through the family immigration process, because knowledge is power, and the more people understand about how the system actually works, the better prepared they'll be. Thanks for watching, and I'll see you in the next video where we'll be breaking down what to expect for immigration policy in early 2026. Until then, stay hopeful, stay prepared, and keep fighting for your family.